Hi everyone, welcome to this session on private international law. Today we're going to look at the doctrine of sovereign immunity or state immunity. State immunity in its broadest sense relates to the protection given to a state from being sued in the courts of other states. Traditionally, it was thought to be an infringement of a state's sovereignty to bring proceedings against it in a foreign country. This is based on the principle of sovereign equality of states and the view that one state should not be allowed to judge another. As such, the traditional rule in most jurisdictions was an absolute one, that is, that states cannot, under any circumstance, be sued in a foreign court. However, in the modern era of international trade, states have become increasingly involved in acts of a commercial or private nature, often through their agencies, organs, or state-owned enterprises. This has promoted a distinction between public or sovereign activities on the one hand and private or commercial activities on the other. A theory emerged that only in respect of its sovereign activities may the state reasonably expect to be immune from proceedings in a foreign court. Further, in the modern world, it is often difficult to determine who a state is. The state itself and the head of the state will certainly enjoy state immunity. However, contracts with the state itself are relatively rare in practice. Typically, commercial parties find themselves contracting with a state-affiliated entity, such as a state-owned enterprise or a state-run project development entity or a trade board. In determining whether a particular foreign state-affiliated entity is part of the foreign state or not, its true control and ownership structure are looked at to see if it's an independent legal person with its own rights and with the capacity to sue and be sued in court. Let's look at how the various aspects of this doctrine are applied in India. India, unlike England, the US and other common law countries, does not have a comprehensive immunity legislation. However, a chapter entitled Suits by Aliens and by or against foreign rulers, ambassadors and envoys in the Code of Civil Procedure 1908 deals with suits against a foreign state in India. Section 86 subclause 1 CPC stipulates that no foreign state can be sued in India without the general written consent of the central government. And Section 86 subclause 2 directs the central government not to accord its consent unless it appears to it that the foreign state 1. has instituted a suit in a court against the person desiring to sue it, or 2. by itself or another trades within the jurisdiction of the court, or 3. is in possession of immovable property situated within such jurisdiction and it is so to be sued with reference to such property or for money charged thereon, or 4. has expressly or implicitly waived the privilege accorded to it under Section 86 subclause 1. The situations enumerated in clause 2 of Section 86, though an ultimate analysis coincides with the generally accepted principles of international law on waiver of immunity, yet clause 1 of Section 86 leaves it entirely to the discretion of the central government to give or refuse its consent to sue a foreign state. And when the central government gives such consent, the foreign state cannot rely upon rules of international law pertaining to jurisdictional immunity of states to defend itself against such consent. Further, neither the CPC nor any other legal instrument in India stipulates procedures to be followed by the central government while granting or refusing to grant the requisite sanction. Now, what are some of these generally acceptable principles of private international law that govern sovereign immunity? 1. And this is something we mentioned earlier, most private parties interact not with the head of state directly, but with various state-affiliated entities like state-owned enterprises or a trade board. This is usually defined in state immunity legislation. For example, the UK Sovereign Immunity Act 1978 refers to the term foreign state to include sovereign or other heads of a foreign state in his public capacity, its government and government departments. It does not confer state status on an entity of a foreign state which is distinct from the executive organs of that government and is capable of suing or being sued on its own. However, it extends immunity to such an entity for acts done by it in exercise of sovereign capacity. Most other common law countries also define state in a similar manner. However, the CPC does not offer an elaborate definition of the term foreign state or enumerate which agencies or instrumentalities of a foreign state qualify for state immunity, and there are a few no decisions in this regard. In one case, the Qatar Airways case, the court stated that since the airlines was a company with a separate legal personality, it could not amount to a state. However, it did not look at the ownership structure or management control of Qatar Airways at all to see whether it was truly a separate legal personality or if it was a mere agent or puppet controlled by the state. However, there is an earlier Delhi High Court case involving the Saudi Arabian Airlines where the court did look at ownership structures to conclude that it was a foreign state for the purpose of Section 86. Next, we need to look at the extent to which the doctrine of restricted state immunity is applied in Section 86. Under the restrictive rule of state immunity, a sovereign state is not immune in respect of the jurisdiction of courts for its commercial activities. In England, this is statutorily expressed in Section 3(1) of the State Immunity Act. If you look at Section 86 of the CPC, Condition B of Subclause 2, also seems to relate to this concept that immunity does not extend to commercial activities of the state. However, Section 86, unlike Section 3(1) of the State Immunity Act, does not contain a commercial activities exception. Subclause 2 only lists the conditions under which the central government may give consent. Lastly, let's look at how compatible the Indian position on waiver is with internationally recognized principles. The general principle that immunity can be waived either expressly or impliedly. An express waiver can be post-commencement of the dispute at the relevant court or in the initial contract itself through the insertion of a waiver clause in the contract as set out on the screen. Further, certain jurisdictions recognize implied waivers such as the fact that the sovereign has entered into a contract containing a dispute resolution clause. Section 86(2)(d) does contain the broad concept of waiver, but the discretion to waive immunity on account of waiver remains in the hands of the central government. Further, there is not too much guidance on what the central government's stand will be on some of the nuances of waiver like contractual waiver and implied waiver. That concludes our broad discussion of how the doctrine of sovereign immunity works and the statutory provisions dealing with the same in India. Thank you for watching.